Good morning. The Senate Subcommittee on Ethical Conduct will come to order. Today is Thursday, March 13th, and it's 9 o'clock sharp. Members, before we get started, we'll do some introductions of senators and subcommittee staff, and I'm going to start with Senator Kunesh.
Good morning, everyone. I'm State Senator Mary Kunesh. I represent District 39.
Good morning, everyone. I'm Taylor Tidwell Bennett, and I'm Senator Champions Committee Legislative Assistant.
Good morning, everyone. My name is Shamika Bogan. I'm President Champions Executive Assistant and the CA for the Ethics Committee.
Lexi Stengel, Senate Counsel.
Andrew Matthews, Senator from District 27.
Good morning. Jeremy Miller, State Senator from District 26, I believe.
Well, it's good to see everyone, and thank you for coming out this morning. Members, on today's agenda, we will consider two complaints. In fact, the first we will address is an amended complaint brought by Senator Barr and others against Senator Mitchell. As folks may recall, the reason why this is an amended complaint is because it was brought before, but there is this matter before us that it amends that complaint that was brought last year, and so we will here only just talk about the second portion of that matter, which is the complaint itself, which is the amendment, because we've already dealt with, or at least we are still having under consideration the first part of that complaint. So what Senator Barr brought forth is an amendment to that complaint. Secondly, we will then address a complaint brought by Senators Jaskowski and others against Senator Mitchell. This is the initial hearing on this complaint required by Rule 55.5, so we will hear that. Just so that members know, for each complaint, the member or members bringing the complaint will present the complaint. They will collectively, if it's more than one, will be given 10 minutes of uninterrupted time. Then there will be an opportunity for members to ask questions. So as they present, we give them that uninterrupted time, and then once they have finished presenting, members of the committee may ask questions. Then Senator Mitchell will then have 10 minutes of uninterrupted time to present her defense. Then there will be an opportunity to ask questions of Senator Mitchell. And just for clarity, when we are dealing with the first amended complaint, we'll make sure that we will talk through that. And then when we get to the second complaint, it'll be only centered around the complaint that is before the body. We will not intermix those two. Finally, the members bringing the complaint will be allowed 5 minutes of uninterrupted time to present a rebuttal if they choose. So the last voice that you will usually hear are those who put forth the complaint. And we will not be taking any action if all four members are not present. All four members are present. That means if any one of you decides to go to the bathroom or step away from the room at any point, please let us know, and then we will take a brief recess because we want to make sure that all members are in the room. Just so that the public knows, it's consistent with this committee, we will not be taking public testimony on this issue. We will only be hearing from those who put forth the complaint. Those who plan to testify today, please come to the testifiers table. This is on the first one that we're talking about, the amended complaint. And once you get settled, I'd like to administer the oath. Senator Mitchell, will you come so we can at least administer the oath, and then you can go back until your time. So if you all would just stand, so that we can administer the oath so everybody is seen. If you'll raise your right hand. You do swear that the evidence you shall give relative to the case, to the cause now under consideration shall be the whole truth and nothing but the truth. So help you God. I do. All right, thank you so very much. So we'll start with the first amended complaint. And since it looks like Senator Barr is not here, Senator Barr, you should probably come to the table because you put forth the complaint. Is that correct?
Mr. Chair,
Senator Lucero.
thank you. There are multiple complainants. Senator Barr is just the first on that list.
So he should come forward because he's the first on the list. And it's okay if he doesn't say anything, but because he's the first on the list, okay? Thank you, Senator Barr. I sincerely appreciate it. All right, so it's going to be 10 minutes. So I will turn it over to the testifiers, and you will be so kind as to introduce yourself for the record once you begin to speak, if that's okay. All right, who's going to speak first? Senator Housley, identify yourself for the record and present your side.
Thank you, Mr. Chair. Senator Karen Housley. Mr. Chair and members of the Subcommittee on Ethical Conduct, thank you for meeting today to consider our enhanced and amended complaint regarding the conduct of Senator Nicole Mitchell. The updated complaint contains new information, including the filing of an additional felony charge against Senator Mitchell. In addition to being charged with first-degree burglary, she has now also been charged with possession of burglary or theft tools, a felony. Furthermore, she has abused due process to delay any action by the Senate while her criminal trial proceeds, and then in turn has used her service in the Minnesota Senate to delay her criminal trial even longer. Let's first review the information regarding her actions on April 22nd, 2024. As it stands today, the facts are appalling. We have a sitting member of the Minnesota Senate facing not one, but now 2 felony charges associated with breaking into her stepmother's home. The new statement of probable cause filed by the criminal prosecutor is incredibly detailed and includes descriptions of where she was found, what she was wearing, and comments Senator Mitchell made both before and after being Mirandized and arrested. At approximately 4:45 a.m., Carol Mitchell, the homeowner and stepmother of Senator Mitchell, called 911 to report an intruder, saying, "I tripped over him. He was on the floor next to my bed. He ran downstairs in the basement." Responding officers arrived at the scene and reported finding Senator Mitchell in the basement of her stepmother's home, hiding in the bathroom. She had removed and hidden her shoes, potentially to mute the noise she would make while moving through the house. She was dressed in all black with a black hat and was carrying a flashlight she had covered with a black sock. A crowbar was found near a basement window. Senator Mitchell is charged with using this crowbar to break into her stepmother's home. While Senator Mitchell was being detained, she confirmed she was there to take things, saying, "Carol, it's Nicole. I was just trying to get a couple of my dad's things because you wouldn't talk to me anymore." Senator Mitchell told the officers, "There were just a couple of my dad's things I wanted to come and get." And as she was leaving, she told officers, "Well, obviously, I'm not good at this." She was read her Miranda warning, a warning that told her she had a right to remain silent, and she proceeded to keep talking to the officers. She said, "I'm just hoping this mistake won't completely F up my life," adding that, "I know I did something bad." She further told officers she'd literally just gotten into the house and again said, "Clearly, I am not good at this."
Our standards of ethical conduct in the Senate.
Will you identify yourself for the record?
Thank you, Mr. Chair. Eric Lucero, Senator from District 30. Our standards of ethical conduct in the Senate dictate in Rule 56.1 that members must adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules. Senate Rule 56.3 declares, "Improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute. There is zero doubt these rules were violated by Senator Mitchell breaking into another person's home to take things that did not belong to her. She is facing not one, but 2 felony charges associated with this behavior. After her arrest, Senator Mitchell made a public post via her Facebook page. In the post, she claimed, quote, "Over the weekend, I learned of medical information which caused me grave concern and prompted me to check on that family member. I entered a home I have come and gone from countless times in the past 20 years, where my son even once had his own room. Unfortunately, I startled this close relative, exacerbating paranoia, and I was accused of stealing, which I absolutely deny," unquote. Senate Rule 56.2 states, "A member must not publish or distribute written material if the member knows or has reason to know that the material includes any statement that is false or clearly misleading, concerning a public policy issue, or concerning the member's or another member's voting record or position on a public policy issue." Senator Mitchell's post does not align with the comments Senator Mitchell made to officers who arrested her. In Senator Mitchell's comments to officers, she admitted she was trying to take things that did not belong to her. Senator Mitchell implied to the public she was conducting a welfare check, even though she claimed to arresting officers she was there to get some things. Senator Mitchell was attempting to minimize the severity of her actions and was spinning an entirely new tale about why she had driven 3 hours in the middle of the night to enter her stepmother's home.
Finally, we'd like to address the delays that have followed the criminal case and the proceedings of this Ethics Committee. Senator Mitchell, last spring, was able to persuade the committee to delay a decision while her criminal trial proceeded. Throughout the summer and fall last year, Senator Mitchell's defense team exchanged filings and motions with prosecutors. In June of 2024, the defense team requested a delay due to a scheduling conflict. The legal teams exchanged evidence and witness lists. The filings dragged on until the court case was scheduled for January of 2025. Then, on January 10th, 2025, just days before the legislative session would begin, Senator Mitchell's legal team chose to assert Minnesota Statute 3.16, which allows legislators to delay trials until after session. As a result, Senator Mitchell has abused due process to first delay the Senate Ethics Committee from considering any information, then turning right around and using her privilege as an elected official to delay her criminal trial. These delays have kept a dark cloud over the Minnesota Senate and failed to deliver justice for the real victim in this case, her stepmother, Carol Mitchell.
This deliberate abuse of due process clearly constitutes a violation of Senate Rule 56.3, which states, "Improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute." The public cannot use their jobs to evade justice and avoid accountability. Moreover, working Minnesotans cannot leverage a criminal trial to prevent their employers from holding them accountable. Due process is important. However, Senator Mitchell has blatantly abused due process attempting to avoid accountability. Lost in the flurry of legal filings and committee hearings is Carol Mitchell. Carol Mitchell is the true victim here. In the middle of the night, she had her home she had lived in for decades broken into, her safety and security completely violated, and now Carol Mitchell is unable to obtain closure because the criminal trial has been drawn out and delayed yet again. While Senator Mitchell is entitled to due process in her criminal case, the Senate should not be complicit in delaying due process. The Senate must take action now with the information we have. If Senator Mitchell wants the truth to be known to this committee, she is welcome to do so here today. This committee has the information necessary to conclude the Senate standards of ethical conduct have indeed been violated. We know breaking into another person's home is not adhering to the highest standard of ethical conduct. We know it's not a norm of Senate behavior to attempt to take belongings in secret from another person's home. We know sharing information that is false or intentionally misleading violates the public trust. We know the abuse of due process brings this body into dishonor and disrepute. This Senate Ethics Committee must act now. Thank you, Mr. Chair.
Thank you to the testifiers. Thank you for your testimony. Now we will go to questions. Any questions from the committee? Any questions? Oh, Senator. And Senator Mitchell, you can come to the table as well, because under the rules, you have a right to ask questions if you want to as well. Okay? Okay, thank you. Any questions for the testifiers? Couple questions. Senator, and you all can decide which person is going to answer. Have you all had an opportunity to read Rule 55, in particular Rule 55.11?
We have it in front of us, Mr. Chair.
And isn't it true that the subcommittee has the right to defer proceedings until the criminal proceeding has been completed? Is that your read of that, or is there a different way to interpret this? It says specifically, if criminal proceedings relating to the same conduct have begun, the subcommittee
Mr. Chair?
Yes.
You're reading, you said 55.11. I think you're reading 55.14.
No, I'm reading.
You have an old
55.
book, Mr. Chair?
You have an old
older
rules
book,
book.
Mr. Chair.
You don't have the updated rules book.
Oh. Thank you. It's the old one. Thank you. So 55.14 used to be 55.11. If criminal proceedings relating to the same conduct have begun, the subcommittee may defer its proceedings under the criminal proceeding until the criminal proceedings have been completed. Is that your read of it, and do you agree that the subcommittee on ethical conduct, that we have the right to defer a proceeding until after the criminal proceedings have been resolved?
Mr. Chair, I do see the word may is indeed in 55.14, giving this committee the discretion to act.
And would you agree that prior to this complaint amending well, let me strike this. Let me say it a different way. Isn't it also true that the new added felony did not bring any new facts to the original petition that was filed April 22nd, 2024? Would you agree with that or not?
Mr. Chair, we would not agree with that. There are additional details that are included in the amended complaint.
And what are those additional details?
Among them, Mr. Chair, would be the prosecutor including an account of a crowbar that was found at the scene, and go ahead.
Yep, Mr. Chair, yes. The crowbar that was found at the scene by the basement window, which was another felony, possession of burglary or theft tools, and then also information of that she was hiding in the bathroom, that she had hidden her shoes under a couch, and more of the details and descriptions of the scene. But the second felony with the crowbar.
And would you agree that if there was a thorough investigation of what was at the scene on the original day that this incident allegedly occurred, that any person who was investigating it would have seen if there was a crowbar at the scene and where her shoes were, where that would not constitute new evidence. Is that correct?
Mr. Chair, we are not a court of law, and this isn't a criminal trial. We are the Senate Ethics Committee, and we abide by our own rules. And as Senator Lucero said, we know that breaking into another person's home is not adhering to the highest standards of ethical conduct. Senator Mitchell herself had said at the scene in the police report, it's documented, she knows she did something wrong. So you can ask Senator Mitchell if she felt it was okay to be found in the middle of the night in her stepmother's basement hiding in the bathroom, if that adheres to our highest ethical standards.
And to anyone that testifies, if you're saying that this is what is represented in the complaint because that is allegedly what happened at the scene, are you also willing to concede that if there was a missing crowbar or a mysterious crowbar by a window, that would have been something highlighted and that the prosecutor had the opportunity to review that and charge her back in April of 2024? Would you agree with that, or would you not agree with that?
Mr. Chair, I am not gonna, or we are not gonna delve into the decision-making of the criminal process, but we are before you today for an ethics process. And the behavior clearly demonstrates that Senator Mitchell has violated the ethical conduct standards of the Minnesota Senate.
And I think that you have been very thoughtful to suggest that there is a criminal proceeding, and that there are people who are in a better position than we are in order to determine and to adjudicate what happened on that day or what didn't. I'm not saying what happened because I don't know. That is why this committee before wanted to wait until we got new information in order to see exactly what happened or did not happen on that day. And it appears to me that that is something that would be clarified after there is a trial. But before I go to the others, I have just one more question. Senator Housley, I think you mentioned that, can you just refresh my recollection, how many continuances did the defense ask for in these proceedings?
There was one in July of 2024 to delay it to June of 2024.
And would you agree that you did have an opportunity to read the judge's order when it came to the judge deciding if the delay or if the continuance should be granted? Did you have an opportunity to read the order?
Yes, Mr. Chair.
And would you agree that on page 6 of that order that the judge wrote, quote, and you can read with me, first, the proposed length of delay is not unreasonable. The defendant requests to try this case after the legislative session concludes in May 2025. That is not an excessively long delay for a felony case that, delay for a felony case which is less than a year old. This is also the first request for a continuance in this matter. This case has not been unduly delayed or prolonged. And then he writes, second, the reason for the delay that the defendant wants to be able to represent her constituents during the legislative session. This is not an illegitimate reason to request a continuance, as it is specifically permitted by Minnesota Statute Section 316. So Senator Housley, you used the word unreasonable delay, and you used some other, terms. Would you agree that the judge is in the best position to decide if something is reasonable or not?
Mr. Chair, again, this isn't the court of law. This is our Senate Ethics Committee. And being delayed criminally isn't the same as being prolonged in ethics.
Senator Housley, I think you said that she unreasonably delayed her criminal proceeding. That's the only reason why I'm asking that question. I'm not trying to be provocative. And you all did include the order in your list of documents, so I thought I would read them and read from it. And so I just wanted to make sure that we're all on the same page, that when there's this wording around unreasonable delay, abusing delay, that is not anything I found in the court's order unless someone can point me to that language that was written by the judge, and then I would recite that. Can any of you point me to language where the judge said that it was unreasonable?
Thank you, Mr. Chair. It is a violation of the public trust and of the ethical standards of this Senate that a person leverages their criminal trial in their attempt to delay the ethics trial or hearing. And that's what's at issue here. Not the goings-on or decisions according to law for the criminal trial. This is, the complaint before us is for the standards in the Minnesota Senate.
And Mr. Chair, if I could, the abuse is in regards to the delay of these ethical proceedings. That's the abuse.
Okay. So I'm going to go to some others who have some questions because I want to make sure that I'm not monopolizing the time. Thank you for answering my questions. I really do appreciate it. Senator Miller?
Thank you, Mr. Chair. So Rule 55.14 says if criminal proceedings related to the same conduct have begun, the subcommittee may defer. It doesn't say we must, it says we may. I have agreed to do that, but we also agreed to come back if there was any additional information. And in this case, not only is there an amended complaint that includes a new felony charge, but in the amended complaint, Mr. Chairman, there is substantially more information that is included in this complaint compared to the old complaint. So I think it's upon us to do our job as a ethics subcommittee to review the information, to hear from our Senate colleagues. We're not here to be judge and jury. We're not here to determine if someone's guilty or not guilty. We're here to determine if one of our members of the Minnesota Senate violated our Senate rules. And if you read Rule 56.1, it says members, that's us, members of the Minnesota Senate, members must adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules that are before us. Okay? It doesn't say, I don't see anywhere in our temporary rules of the Senate, state of Minnesota, where it says we as members of the Senate are here to determine whether one of our colleagues is guilty or not guilty. I don't see that anywhere in the rules. We are here to determine whether or not one of our colleagues violated the rules of the Senate. And then if you look at Rule 56.3, Mr. Chairman, it says improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute. So that's what we're here to determine today, Mr. Chairman, and I would like to hear from Senator Mitchell, and then I have a few questions after we hear from both parties. But I just want to make it clear, we're not here to determine whether or not anyone's guilty or not guilty. We are here to determine if one of our Senate colleagues violated the rules of the Minnesota Senate.
Senator Miller, I would agree with you that the rule says in 55.14, if criminal proceedings relating to the same conduct have begun. I think you will agree with me that there's a process that is ongoing from the same conduct, that the amendment does not bring any new information that would suggest that it's different conduct. And the second thing that would hope that you would agree. You're right that it says may. We don't have to postpone it, but we know that it's been there's been the precedent of this body that if there's a criminal proceeding going forward, that we would, wait until that has been done. And even though we keep saying that we're not looking at guilt or innocence, innocence, but I've heard us reading from the complaint, which is a criminal complaint that has not been adjudicated as of yet. So there's a process in order to test any information that is in a complaint. That's the only thing that I'm saying, because there's this little thing that's called due process. Senator Miller.
Thank you, Mr. Chairman. Well, I would love to reference the body cam footage, but that hasn't been available to us. So we are just trying to figure out and work off the information that's available to us. And one of the members in front of us had mentioned something about a crowbar. And you were questioning, well, shouldn't the officer see the crowbar when they're on the scene? Mr. Chairman, it was 4:45 in the morning. I don't know what it's like in Minneapolis, but down in Winona, it's still pretty dark at 4:45 in the morning. So if the victim in this case gets called back later the next day or later that morning when it's light outside and says, hey, officer, there's a crowbar in the window well of my house that's not mine, I would not expect that to be in the original statement of probable cause if it happened later in the day. And then furthermore, the following day, Mr. Chairman, it says one of the officers returned to the victim's residence on April 25th. So that was a couple days later. I believe this all happened on April 22nd, right? So this was 3 days later. And I'm just going to read right from the statement of, sorry, I'm not an attorney, I have to look at this, statement of probable cause. It says that the officers returned to the victim's residence on April 25th, so this was 2 or 3 days later. At that time, it was determined that a small sliding basement window where Mitchell's backpack was shoved, and if you remember from the first complaint, this is the window that Senator Mitchell said that she entered, so I have some questions for her. Which window did she actually enter in the basement? Because the original window that she said she entered, they determined it was too small for a human to fit through. So then the officers determined that the larger egress window next to where the crowbar was discovered was Mitchell's most probable point of entry. The officer noted faint pry marks on the window. He also observed traces of loose dirt around the windowsill and on the desk immediately inside the egress window. Mr. Chairman, that is substantially new information compared to where we were when we last met as an ethics committee.
Senator Mitchell, maybe you or the testifiers can answer this question that I think would help. Can you tell me the date that the prosecutor amended the complaint? What date was it?
Mr. Chairman, it looks like it was electronically signed, so I'm guessing that's the day that it was submitted, was February 6th, 2025.
So Senator Miller and or the testifier, are you suggesting to me that 3 days later, after a officer goes out there allegedly, and the only reason why I'm saying allegedly, I'm not questioning them because this information has not been tested. So are you telling me that 3 days later they go out and discover something and there's not the opportunity for the prosecutor to amend the complaint before February of 2025? And the answer is no, there's nothing that would suggest that a prosecutor cannot amend the complaint. And the only thing that one could question, with all due respect to the prosecutor and law enforcement, is that it was more political than it was factual. Because if you recall, had Senator Mitchell gone to trial January 27th of 2025, this new count would not have even been a part of it. So it was not until after the judge entertained giving a continuance in this matter, did the prosecutor now come with what you're now describing as new information that was realized, if true, 3 days after this first incident occurred? So, Senator Miller, I agree. The prosecutor can do whatever they want.
Mr. Chairman?
They have the right to amend. They have the right to do whatever they want. But I'm sure we all agree that if this alleged information was available 2 days after or 3 days after on April 25th, it does not take any prosecutor to amend a complaint several months later after the date of the trial and say that's new information. They had it, if they had anything, back in April.
Mr. Chairman,
Senator Miller.
I don't know the answer to that question because I'm not a prosecutor, but I do know that we are here today to determine whether or not one of our members violated Rule 56 of the Senate rules, Senate State of Minnesota rules. 56.1 says members must adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules. I would argue that state law was violated as well as the rules of the Minnesota Senate. Mr. Chairman, Rule 56.3 says improper conduct includes conduct that violates a rule of administrative policy of the Senate, that violates accepted norms of Senate behavior. I'm not sure that breaking into your stepmother's home is an accepted norm of Senate behavior. Also, Mr. Chairman, Rule 56.3 says that betrays the public trust or that tends to bring the Senate into dishonor and disrepute. Mr. Chairman, that is what we're here to determine today.
Senator Miller, the only reason why I went down that road, and then I'll get to you, Senator Matthew, the only reason why I went down that road is because you were the one who said that there's new information that has been articulated in the complaint that wasn't available before.
Mr. Chairman, I said there was substantially new information,
that's
which there is substantially new information in front of me right now.
I want to make sure that we don't interrupt each other, because when you were talking, I was very quiet. I didn't say anything. But if you want to clarify it, I'll say substantial from your vantage point. The only reason why I raised it is only because I was responding to what you said as it pertains to substantial new information, and I'm saying it's not substantial and it's not new information. There will be a jury that would decide whether it's substantial enough in order for the person to be found guilty beyond a reasonable doubt, and that is this. That will let us know if state law was violated. Senator Matthews.
Thank you, Mr. Chair. Couple points I want to bring out with this discussion. Excuse me. Long description about the process and what the prosecutor chose to do and not do. This committee had agreed last year the right to come back if we got new information. It's basically irrelevant to this committee how or when we got that new information. Fact is, we did get new information because I went through as well looking for and highlighting what new facts are in the updated complaint that we didn't know about from the previous complaint, and it is significant. There's a lot of highlighted information that is on this. So it's irrelevant as to how we got it. We can question if the prosecutor was political, not political. You know, as an attorney, the prosecutor has discretion to do that in whatever time frame that they want to do or choose to do. They have significant prosecutorial discretion. At the end of the day, the bottom line is this committee now has information that we didn't have publicly released last year at the time of the first complaint and the first hearings that we did. So it is well within our committee's rights to consider this and determine whether or not we want to act on this new information. The second point that I want to make is we go round and round in circles about this word may from Rule 55. It's now Rule 55.14 in our rules. And we do not simply have to rely on the decision that this committee made last year in our hearings at that time, because new significant factors can change this committee's determination as to whether or not we will stay on, as we did last year, deciding to defer proceedings until more steps had occurred, or whether this committee now wants to change its mind and move forward on that. The new proceedings, you know, where we had left off in a hearing last year, and I forget which month it was, but I believe it was while we were still in session, was we had set a date for after a potential June 2024 hearing in order to determine if there was new actionable information at that time. And you know, as well as everyone on this committee, that June 2024 got delayed to January 2025. And then, as the complainants have alleged here in this new complaint, just a few days before that hearing, the defense invoked the Minnesota statute. Was a second delay from January 25, and now it's, I believe, scheduled in June 25. And there's a whole argument of leveraging the Senate process against the judicial proceedings while simultaneously leveraging the judicial proceedings against our Senate process here. So this committee gets to decide how many times that circle can be, how many times we can run around that merry-go-round before deciding that we're actually going to take action here. And the final point that I'm going to throw out, Mr. Chair, with that is the trial is now scheduled for June, and we all hope that we are done on time here in this session. However, there is a non-zero chance, hopefully it's a very, very small chance, but there's a non-zero chance that the legislature could find itself in session in June of 2025. And the question definitely is posed out there. Is there potentially going to be a repeat of this again, asking for a delay yet again from June 2025 to some future date? And what is the committee then going to do at that point, and how long we're going to continue to wait for this? So with those reasons, it is well within this committee's rights to determine if we will still use the may defer its proceedings, or if we decide it's time for us to decide not the criminal trial. All of that is not, we're not the judge and jury, but we can decide whether we should change course and decide whether the conduct here is in violation of our Senate Rule 56.
So thank you, Senator Matthews, for those words. I will agree, just so that we're clear, we did agree as a committee that we will come back if there's new information. And every time we heard something, as we approached the hearing, I made sure that we called everyone to say, here's the information. We even provided it to you in writing, what we learned, and then for us to determine if that was something that would require us to come back in, because I've always been committed to that. And so, and so as a committee, we can decide, and I think we should either decide if we're going to delay this until after the criminal proceeding, or take a vote one way or the other. It's fine. I do think that that we would get done on time. Maybe I'm just a hopeless optimist, but I see Senator Draheim shaking his head, but I'm hoping that we do get finished in time. But I can't predict the future, and I can't predict what is going to happen. I can only be hopeful that we will finish on time, and that Senator Mitchell will have a right to due process, and she'll get a chance to go through her trial. And so before I go to asking the committee, important questions, I'm going to recognize Senator Miller.
Thank you, Mr. Chair. I'm even more optimistic. I think we're going to get done early this session. That's what I'm hoping for. I do want to say publicly, you have been very, very good about communicating with the committee, and we have agreed that if until new information is available to us, that we would not come together again, and you have done a tremendous job of communicating with us. But the reality is there is substantially new information in front of us that we're discussing today and reviewing. I'm wondering, are we going to hear from Senator Mitchell next? Okay,
Yes.
thank you.
All right, thank you. Seeing no other questions, you all will have an opportunity to do a rebuttal if you like. Okay, thank you so very much. Senator Mitchell, if you'd be so kind as to join us at the dais. Senator Mitchell, you are under oath. As the other testifiers, you did so kindly come forward and you were sworn in. As you know, as I indicated earlier, that those who are bringing the complaint, they would have 10 uninterrupted minutes of an opportunity to talk. You now have your 10 minutes, and you can use that 10 minutes in any way that you would like. If you will identify yourself for the record and then give us your testimony.
Thank you, Mr. President, members of the committee. I appreciate your time. I am here to ask that the committee continue to follow Senate custom and delay any decision until after any allegations are completely resolved. Not only is it Senate custom, but it's the will of the people of Minnesota who we all represent. There was actually a poll that came out just last month asking Minnesotans from around the state whether a decision by the Senate should be made now or wait until the conclusion of the matter in question. And the majority of people want to wait. And while it's not a poll, the feedback I've received from my own district has been even more clear. People reaching out every day to tell me what's important to them or how I can help them in some way. A lot of anxiety right now based on things coming down at the federal level. I have a growing district, and my district population is estimated now at almost 87,000 people. They have asked me to stay and keep working for them, and they deserve representation. So again, I ask that you follow the course that you have already taken, the course of Senate custom, and delay a decision until the appropriate time. Thank you. I'm sure you understand that beyond this statement, I will not be able to comment further or answer questions related to this ethics complaint.
Thank you, Senator Mitchell. Members, any questions? Senator Miller.
Thank you, Mr. Chairman. Senator Mitchell, is there a police report available from the incident? And if so, have you seen it?
Senator Mitchell.
Senator Miller, as I have stated, I am not able to answer questions, which to me is the very crux of why we should delay this, because I have a constitutional right. I would very much like to answer questions, and I look forward to the ability for due process to play out and for myself to be able to do that, but I cannot at this time, which is exactly why we should delay the proceedings.
Senator Miller.
Thank you, Mr. Chairman. Senator Mitchell, is there body cam footage available from the incident? And if so, have you seen it?
Again,
Senator
Senator
Mitchell.
Miller, I cannot answer questions. There is an extensive public record which you are able to look at.
Senator Miller.
Thank you, Mr. Chairman. One of the things that I noticed when I was reviewing the original complaint and then the amended complaint, not only is there an additional felony charge included in the amended complaint, but there's substantially more information on what happened on during the incident on April 22nd. And Mr. Chairman and Senator Mitchell, one of the things that I saw that was in the amended complaint but is not in the original complaint is this quote. This is quoted right from the complaint. The victim stated when she called the police that there was an individual on the floor next to her bed and that the individual ran into the basement. The victim would later add that she had stepped on the individual briefly before they got up and fled the room, end quote. My question for Senator Mitchell, Mr. Chair, is, Senator Mitchell, were you on the floor next to your stepmother's bed at 4 o'clock in the morning, or approximately? The phone call was at 4:45 a.m., so I'm not sure exactly what time, but approximately 4 o'clock in the morning, 4:45 a.m. on April 22nd, 2024.
Senator Mitchell.
Again, Senator Miller, I have a right under the Constitution to not be answering questions. I have made that very clear, which is exactly why we should wait until the time that I can answer questions.
Mr. Chairman, I have one more question for now. And I did not see this in the statement of probable cause, but Senator Lucero mentioned it in his comments that at some point, Senator Mitchell, you had mentioned that you were doing a welfare check on your stepmother. And my question is, because what is in the statement of probable cause is that you entered your stepmother's home through a basement window. So my question for you is, if you were doing a welfare check on your stepmother, why did you enter her home or break into her home through a basement window?
Senator Mitchell.
Senator Miller, my previous answer to you stands.
Senator Miller.
Thank you, Mr. Chairman. That, it sounds like I'm not going to, actually, Mr. Chairman, I have a question for you, a legal question, okay? So just generally speaking, nothing to do with this ethics complaint, but my question for you as an attorney and someone who's much more familiar with this than me, does state law prohibit an individual from using a tool like a crowbar found in the window well of the victim's house to break into someone else's home and commit burglary and theft? And if that is prohibited in state law, what would the consequences be if someone were to be found guilty for that?
Thank you for that question, Senator Miller. As you probably know, that every case based on the facts are different. So even though that there's a statute that we have that a person is accused of breaking or violating, the whole reason why we go through the legal process and have a trier of fact is because the prosecution has the burden to prove the person guilty beyond a reasonable doubt. And so there's so many other things that would become a part of that process. The prosecutor would have to put forth witnesses, any DNA, any video information. But again, there's a process, and then a judge can decide based on a person's criminal history, if a person is found guilty, what should be the consequence. So I don't think there's a mandatory minimum under the statute that you're looking at, or a person can be exonerated. Like, it happens over and over again. I win, cases over and over again where there's a probable cause statement that makes them look like they're guilty, but in fact, once you go through the process, they're found innocent. That's the importance of due process, because under our Constitution, a person has the right to confront any accuser. And simply because someone says it happened doesn't mean it happened. And the last thing I'll say about this, which is kind of a little levity, is if you ever looked at My Cousin Vinny. And so if you look at that movie where someone said they were clear that this is what happened, and then on cross-examination, when it was determined that they needed glasses, didn't have the glasses on, there was obstructed view, there's all these other things, it turned out that the person's testimony was not as strong as what individuals thought. So it's a long way to answer your question, but that's the whole reason for the process, is so we can test the validity of it. And then if a person is found not guilty, then the case goes away. But if they're guilty, then there would be a sentencing, and then you look at the person's record and so on and so forth.
Very good. Thank you, Mr. Chairman.
Senator Matthews.
Thank you, Mr. Chair. Thank you, Senator Mitchell. Mr. Chair and Senator Mitchell, I'm going to ask you a couple of questions. I'm not going to be asking substantive questions about what's in the complaint. That's been well established over several meetings that you are invoking your constitutional right to not answer the substantive questions to the case. I am going to ask you a few process questions, because that is related to some of why we have this amended complaint here before us. So at some point last year, there was, I don't know if it was the trial, but there was some form of hearing that was scheduled in June of 2024 that your attorneys then needed moved later than that date. Is that correct?
Senator Mitchell.
There was a hearing scheduled for June that my attorneys had a conflict with. I believe it was rescheduled 3 weeks later.
Senator Matthews.
Thank you, Mr. Chair. At some point then, and I don't know how many reschedules happen, but at some point then, the trial date got scheduled for January 27th, 2025, at some point last summer or fall. Is that correct?
Senator Mitchell.
Senator, that is correct. All of this is in the public record, and I am getting to the point where I will not be able to talk about this again.
Senator Matthews.
Thank you, Mr. Chair, and thank you, Senator Mitchell. Yes, I'm not going to be asking about anything in the record. Did your attorneys agree to the January 27th, 2025 trial date when that date got set?
Senator Mitchell.
Senator Matthews, I am going to not answer additional questions at this time. I was not part of that. That is a question for my attorneys who are not able to be here today.
Senator Matthews.
Thank you, Mr. Chair. Thank you, Senator Mitchell. I would be asking them these questions if they were here. So the request to continue off of the January 27th date was made on January 10th, 2025. I guess the question I would be asking to your attorneys is if they were aware that January 27th fell within when the legislature was in session at the time that they agreed to that hearing. So I'll pose that to you. I know that your attorneys aren't here, but that's the question that we're posing.
Senator Mitchell.
Senator Matthews, you're now asking me to tell you what a different person did or did not know. And again, I'm not going to continue commenting on this.
Senator Matthews.
Thank you, Mr. President. Thank you, Senator Mitchell. No, there's communication between attorneys and clients. Sometimes you do know why you're doing different things or different motions, but I understand. So the request got filed on January 10th, 2025 to continue the trial and invoking Minnesota statute 3.16. So my question is, was it on January 10th or at what earlier date did you and your defense team determine that it was within the legislative session and that you would need a continuance?
Senator Matthews. Senator Mitchell.
Senator Matthews, as someone who has been to law school yourself, you know that conversations between a client and their attorneys are privileged and therefore are not within the scope of this.
Senator Matthews, she does have a point. So if your question is going to keep going to attorney-client privilege, I'm not sure if that's the best use of our time. Senator Matthews.
Mr. Chair, I am in no way asking her to disclose what her and her attorney's strategies are, what their defenses are going to be, what attorney work that they've been doing. I'm all talking about calendar dates, and I just have one question left on it, Mr. Chair. Mr. Chair, I believe, and Senator Mitchell, I believe the trial is now scheduled in June of 2025. As I indicated earlier, hopefully the legislature is done at that point, but there is a non-zero chance that the legislature is still in session at June 2025. So if we come to that date again, will it be your intention to file a similar continuance request under Minnesota statute 3.16 to delay it again off of June 2025?
Senator Mitchell.
Senator Matthews, again, I am not going to be answering questions about conversations with my lawyer or related to details behind this case.
All right.
Senator Miller. Were you done, Senator Matthews? Okay. Senator Miller.
Thank you, Mr. Chairman. I have a question for Senator Matthews. I don't know how often I've heard the term non-zero chance. Are you saying that there could be or could not be a chance that we're done on time? That's my question for you.
That's
I'm
a
just
pretty
kidding.
good question there, Senator Miller, because I wasn't quite sure.
I don't know if I've heard that term very often. Senator Mitchell, just for clarification, I have a question. Did you state earlier that when this January 27th date was set and agreed to, that your attorneys did not consult with you about that date? Did I hear you correctly when you said that?
Senator Mitchell.
Senator Miller, I do not recall phrasing it in that way, but I'm sure Senator Champion could speak to the scheduling process better than I could, but I think it has a lot to do with other people's schedules.
Well, so Mr. Chairman, Senator Mitchell, did your attorneys consult with you when the January 27th date was set? Did they consult with you, and was there agreement amongst you and your attorney?
Senator Miller, that gets into attorney-client privilege, but I'll let her answer. Senator Mitchell.
Senator Miller, I was informed.
Thank you.
Senator Miller.
That's all I have, Mr. Chairman.
Any questions? And if there are questions, let's please stay away from the facts, because she's already made it very clear that she's not going to answer specific questions related to the case. So if you could help us out, that would be great. Senator Lucero.
Thank you, Mr. Chair. And Senator Mitchell, do you acknowledge that a criminal trial and this ethics committee are different processes?
Senator Mitchell.
Senator Lucero, based on how some people are trying to play it out, it seems like there might be some confusion, but yes, they are different processes.
Senator Lucero.
Thank you, Mr. Chair. Thank you, Senator Mitchell. Do you acknowledge that the Senate rules of ethical conduct are unrelated to criminal proceedings?
Senator Mitchell.
Senator Lucero, I am not, I do not fully have the rules memorized. I believe there is some overlap in how things relate, and so I would leave that to experts like Senator Champion.
Senator Lucero.
That's all I have, Mr. Chair. Thank you.
Senator Housley.
Thank you, Mr. Chair. And Senator Mitchell, off of what Senator Lucero said, violating ethical conduct of the Minnesota Senate, your attorney was asked why Senator Mitchell allegedly wore all black and carried a flashlight with a sock over it. And your attorney said that I agree that all of these circumstances would suggest that was her plan to go in and out without disturbing anyone, as well to try and receive the items that are hers. I believe she was trying to protect herself from being noticed. I'm not going to deny that. She wanted to basically make a check and retrieve a couple of items that she felt were being wrongfully withheld from her despite earlier promises. He said that to the Star Tribune, April 23rd, 2024. So I don't know if you've talked to your attorney about what he stated, but do you believe that that would be a violation of our ethical conduct in the Minnesota Senate?
Senator Mitchell.
Senator Housley, I can't speak to what someone else said. I can say that I did not have a lawyer officially hired on April 23rd, so I find that statement confusing.
Senator Housley.
Mr. Chair and Senator Mitchell, when we had our last ethics committee, you had Bruce Ringstrom Jr. here as your attorney, and this was Bruce Ringstrom Sr. As part of the same firm representing you according to his son on the last ethics committee trial. So you're saying he was not hired as your attorney?
Senator Mitchell, to the question, did you hear the question?
Senator Housley, I would have to look at my records, but I officially retained that firm late in that week.
Senator Housley.
Which was not the 23rd.
Oh, sorry about that. I didn't mean to cut you off. Senator Housley, any follow-up before we go to rebuttal.
Yes, just one more. So I just want to confirm for the record that the booking photo that was taken April 22nd of you dressed all in black at the Becker County Jail was indeed you?
Senator Mitchell.
Senator Housley, again, I am not going to comment on details of the case.
Thank you, Mr. Chair.
Thank you. Seeing no further questions, thank you, Senator Mitchell. We will now welcome Senator Lucero and Senator Housley back to the table along with Senator Barr. According to the process that I laid out, once the questioning was done with Senator Mitchell, that there would be a rebuttal if those who brought the complaint wants to do a rebuttal. And if so, we will give you 5 uninterrupted minutes if you want to do a rebuttal. And then the committee will discuss next steps. Are we ready?
Thank you, Mr. Chair. Mr. Chair and members of the committee, thank you for taking time today to consider the new information in this matter. Last spring, the Minnesota Senate returned from its Easter Passover break short a member. One of our colleagues was found dressed all in black by police officers in her stepmother's basement after a frantic 911 call reporting an intruder. That intruder was member Senator Nicole Mitchell, who has been charged with 2 felonies. What happened in the early hours of April 22nd, 2024 is a disappointing and sad episode. Many of us have experienced difficult losses and strained relationships of complicated family dynamics. But that's absolutely no excuse to break into anybody's home through a basement window, dressed all in black, to take things.
We contend Senator Mitchell's actions in April of 2024 violated Senate standards of ethical conduct in 3 ways. First, Rule 56.1 requires members to adhere to the highest standards of ethical conduct. Senator Mitchell is charged with 2 felonies. This fact alone is unprecedented for this body. Further, she was literally found at the scene of the crime by police officers in all black clothing and a black hat. This body can definitively conclude such behavior is simply not the highest standard of ethical conduct. Ask yourselves, does driving 3 hours in the middle of the night and being found by police officers in someone else's basement constitute high ethical standards? Any reasonable person would say no. Second, Rule 56.3 identifies improper conduct as conduct that betrays the public trust. The public trust has clearly been violated. We must not allow it to become an accepted norm for senators to engage in felonies and continue to vote on legislation. Third, Senate Rule 56.2 prohibits members from publishing false or clearly misleading statements. Senator Mitchell's published statement is in direct contradiction to the comments she made to arresting officers after being read her Miranda rights. Senator Mitchell offered a misleading account of her actions to generate sympathy for her situation. Lastly, Senator Mitchell has violated Senate Rule 56.3 by abusing due process, using her position to first delay ethics proceedings in the Senate, then turned right around and leveraged her position in the Senate to delay her criminal proceedings. The public's trust has been violated. When this committee met last May, it deferred action to after Senator Mitchell's next court proceeding. It was argued to this committee that the legal process was only a few short weeks away, and it could hold off decisions to allow the trial to proceed. The committee never reconvened because the trial faced delays throughout the year. We are here today with more information from the court case. and the trial delayed yet again due to Senator Mitchell's service in the legislature.
Again, Mr. Chair, the real victim in this case is Carol Mitchell. Recently, Carol Mitchell has been diagnosed with a cognitive impairment. All of us know someone who has been diagnosed with a memory disorder, and in these cases, days can matter. These delays to manipulate the system and the Senate rules are all by design to make it harder for Carol Mitchell to speak about her experience with clarity. Due process is foundational to this country, but what has happened here is not due process. It's a manipulation of procedure to prevent both the courts and the Senate from taking action to hold Senator Mitchell accountable for her actions. This committee owes it to the public to take seriously its duty to hold our members to the highest standards of ethical conduct. The rules of conduct outlined in this little rule book should not only be for show, Mr. Chair. Instead, these rules, our Senate rules, should carry weight and meaning if they are to deliver on their purpose.
Thank you so very much. Thank you for your testimony today. The committee will now decide what the next step should be or decision around this case. Members, under Rule 55.5, we met the mark of within 30 calendar days after receiving the complaint. We are here meeting, and there are a couple options available to us. One is for there to be a finding of no probable cause. We can vote to defer action until a certain time or proceed with an investigation. Any suggestions as to how you, or which vote you'd like to take first, or if there's a motion? Senator Matthews.
Mr. Chair, that was going to be one of the questions that I think is best posed for you to answer as to your intention with this. If you were still remaining of the position that we had last year, given all this new information, I think our positions have been pretty clear on this all the way along, but we are needing to hear what you and your side is believing with the May and the rule and the new information and the delayed trial dates and all of that.
Thank you. Senator Matthews, from my perspective, this is an amendment to an ongoing criminal proceeding that's already in process. There's a trial date, and the information with some new facts, whether you say it's substantial or not, does not move me one way or the other to say now that we have all the information, because whatever is articulated in the probable cause statement, those are allegations, and they're not determined until there's a proceeding, whether a person makes an admission, and there's been nothing that says that Senator Mitchell has made any admission, and there's nothing that would suggest that we have all the information. So from my vantage point, we should continue to delay it until after the criminal proceeding, and then whatever happens there, we can, certainly reconvene on that this notion. And between now and then, if there's some admission or there's some plea agreement or something happens, then that would be new information, because then we have had the opportunity to hear from Senator Mitchell in that context. Senator Miller.
Thank you, Mr. Chairman. What is the process? Let's say that this ethics subcommittee takes a vote and agrees that one of our members, just generally speaking, did violate the rules of the Senate. What are the next steps? Does that go to the full Rules Committee and then to the Senate floor, or how does that process work?
Yeah, you got it right. We would have a recommendation, whatever we decide to do, if we believe someone should be expelled or censored or whatever it is, that would go to the Rules Committee, and then the Rules would bring that to the floor.
Okay, thank you, Mr. Chairman.
Senator Kunesh, and remember that we have a whole nother complaint that we have to hear as well. Senator Kunesh.
Sure. I just want to ask you, or ask the experts here, have we ever in the history of the Minnesota Senate acted on a complaint involving a criminal case before the legal case has been completed or concluded? Have we ever done that before? And I say that because we're talking about norms and practices here in the Minnesota Senate. Do you know if that has ever been the case?
I will go to Ms. Stengel, who can speak to that question.
Thank you, Mr. Chair and Senator Kunesh. To my knowledge, the Senate has not taken action on an ethical complaint brought before the Subcommittee on Ethics where a member is also the subject of a criminal complaint until the criminal complaint has been finally discharged. There are several instances where there's a criminal complaint and the member has either left office or it's been otherwise resolved before the ethical process is played out.
So if we were
Senator
to,
Kunesh.
thank you. So if we were to vote on something like that, that would certainly vie away from our general practices in the past. And I think we really need to take that into consideration. And if that's something that we want to create a presumption or a future action, I think we need to think about that hard.
Senator Miller.
Thank you, Mr. Chair. Along the same lines, I'm just wondering if we're going back in history, do we know if we've ever had a member that's been charged with two felonies?
Ms. Stengel.
Mr. Chair and Senator Miller, I do not know the answer to that. I know that there have been members that have been charged with various crimes, some of which may have been a felony, but I don't know the number of counts.
Thank you.
Seeing no other question, Senator Matthews. Yeah, motion. Go ahead, Senator Matthews.
All right. Thank you, Mr. Chair. I appreciate your perspective on how you view the facts with this case. However, I am going to, with the new information that we had in here, I am going to make a motion that this committee make a finding of probable cause and make a recommendation to the Rules Committee for expulsion. That is my motion, and I believe I need to request a roll call vote for that.
That's up to you.
I will request a roll call vote, Mr. Chair.
Roll call requested, roll call granted. Any questions on the motion that is before? Seeing none, Taylor, Ms. Bennett will take the roll.
Senator Kunesh.
No.
Senator Matthews.
Yes.
Senator Miller.
Yes.
Chair Champion.
No. There being 2 ayes and 2 nays, the motion is not adopted. Any other motions? Well, let's go through them then. We've already heard the motion for probable cause. I will now go to the motion to see if there should be additional investigation. Motion before the body is whether there should be further investigation. Do I need someone else to make that motion, or can I just make that motion because it's okay?
Mr. Chairman, so the motion has been made. What are the results? What if this is a upward? If it passes or it fails, what are the results of each of those votes?
Results if Senator Kunesh makes the motion, and if she votes no, and I vote no, and you two vote yes, then it fails. There would be no investigation. And then we will then go to whether the committee wants to defer this action until after the trial. Mr.
Chairman, what if all 4 of us vote yes? Then what happens?
Then an investigation would be launched.
In Mr. Chairman or council, what does that mean?
Senator, I will turn to Senate Counsel, Ms. Stengel, to the question.
Thank you, Mr. Chair and Senator Miller. That's up to the subcommittee to decide. It could be additional hearings with additional witnesses. It could be looking to have somebody outside come in. It's really up to the subcommittee to determine what that investigation would look like.
All right. Any other questions, Senator Matthews?
Mr. Chair, could you just reread? It appears someone made an official motion. Could you just repeat
Yeah, the
what that
official
is?
motion is that the committee should proceed with an investigation. That is the motion made by Senator Kunish. All right? Are we requesting a roll call? Roll call requested. Roll call granted. And we'll turn to Ms. Bennett to take the roll.
Senator Miller,
Yes.
Senator Matthews,
Yes.
Senator Kunish,
No?
Chair Champion.
No. There being 2 ayes and 2 noes, the motion fails. Now we are on whether there is going to be a motion to defer until after the trial. Senator Kunish? That's the motion that is before the body. Now we will discuss it. Senator Miller?
Thank you, Mr. Chairman. Do we have the same commitment from you that if new information becomes available, you mentioned earlier if there's a plea deal or if body cam footage becomes available, whatever that new information might be, then we would come together again as a ethics subcommittee to review that new information?
That's my continued commitment.
Thank you, Mr. Chairman.
Okay, thank you. I just need to answer a question. We know what the motion is that right? All right.
And I'll ask for a roll call on that, Mr. Chair.
Roll call requested, roll call granted. Ms. Bennett will take the roll.
Senator Miller,
Aye. Yes.
Senator Matthews,
Yes.
Senator Kunish,
No?
Senator Champion.
Yes.
And I will change that to a yes. Thank you. I was a little confused there for a minute. Thank you.
No problem. Again, there being 4 votes to delay until after the trial, the motion prevails. Members, and that's a part of our consistency around wanting to make sure that the trial happens. So thank you. Now, with that being stated, we will now go to the second complaint. Members, I also just want you to be conscious of the time. I'm not rushing anyone. I'm just making sure that everyone knows that. We'll now move to the complaint that's brought by Senator Jaskowski. I'll ask Senator Jaskowski to come forward to make the presentation of his complaint. Are you having any other witnesses, Senator Jaskowski, or members?
Mr. Chairman?
Senator Miller.
I'm sorry to do this, but can I ask for a quick break to rinse out my coffee cup and fill it up with water quickly before we start the next
Yes.
complaint? Thank you. I'll be right back.
Brief recess until he returns. And then I should. the committee will come back to order. All right, Senator Jaskowski, will you be so kind as to stand? And if I could ask Senator Mitchell to also come up to the table as well so we can do the oath. The reason why we're doing the oath, just so that everyone understands, is because this is a new complaint, and I want to make sure that we have it all covered. All right? And there's no one else that's planning to testify as far as senators or anyone, is that?
No, Mr. Chair.
Okay, thank you so much. All right, if you'd be so kind as to raise your right hand, do you swear that the evidence you shall give relative to the cause now under consideration shall be the whole truth and nothing but the truth? So help you God.
I do.
Thank you so much. As I mentioned earlier in the previous presentation, that you'll have 10 uninterrupted minutes for you to present your side, and then the committee can ask questions, and then that will be followed by Senator Mitchell, 10 uninterrupted minutes, and then the committee can ask her questions. And if you choose, you can have 5 minutes rebuttal. But also, just so everyone understands, that if we're not done by 10:45, we then will come back at 5 p.m., just so that everyone is clear. All right, with that being said.
Mr. Chairman, just so everyone knows, I am not available at 5 p.m. tonight. My son has a choir concert in Winona, so 5 p.m. will not work for me tonight.
Okay, then what we'll do is my understanding that was communicated to everyone, understand the whole issue about your kids, so then we'll have to find a different date, and it won't be immediate. I just will say that, okay? Senator Jaskowski, to your complaint.
Thank you, Mr. Chair. Mr. Chair, members of the Subcommittee on Ethical Conduct, thank you for taking the time to review our complaint today. This complaint is simple in its form. It is not about the actions early in the morning of April 22nd, 2024. Indeed, whether or not Senator Mitchell is found guilty in her pending criminal case is irrelevant to this complaint or the facts from which it arises. This complaint is entirely about whether Senator Mitchell's action prevented a vote of the Senate on her political future meets this body's standards of ethical conduct. The Minnesota Constitution grants the Minnesota Senate the authority to regulate its members' conduct. Article 4, Section 7 specifically states that each house of the legislature may, quote, punish its members for disorderly behavior and with the concurrence of 2/3 expel a member, unquote. On January 27th, Senator Jordan Rasmussen moved that the Senate consider the expulsion of Senator Mitchell. This motion would have required a 2/3 vote of the body to be adopted. After a ruling from the Senate President that this motion was out of order, the ruling of the President was appealed. The body was asked, quote, shall the decision of the President be the judgment of the Senate? Unquote. This vote only required a majority to overturn the decision of the President, which would then allow a motion to expel to be considered. The vote failed 33-33, with Senator Mitchell casting the deciding vote. If she had not voted, there would have been 33 votes to overrule the President and only 32 to uphold the President's ruling, and led to a vote on her expulsion. Prior to the vote, Senator Westrom asked the Senate President to clarify whether Senator Mitchell was present, if she had filed a recusal from the vote, and if she was required to do so. President Champion confirmed Senator Mitchell, was present, and that she had not filed a recusal statement, and that it was the responsibility of any senator facing a conflict of interest to self-enforce our ethics rules by declaring the conflict itself. Minnesota statute and Senate rules both outline the process for handling conflicts of interest and expect members to disclose any issue for which they have a financial conflict. Members are expected to abstain from votes for which they have a financial interest. Senator Mitchell did not disclose her conflict and did not abstain from a procedural vote that stood in the way of the Senate conducting a vote on her expulsion. Senator Mitchell had 10 months to contemplate her conflict on this vote. She was reminded of it on the floor prior to voting. She voted anyway. Senator Mitchell deliberately and defiantly violated the rules of ethical conduct of the Minnesota Senate. Her vote was the deciding vote that prevented the expulsion vote from occurring. There can be no greater conflict of interest than the threat of losing one's job in its entirety. Senator Mitchell has a conflict of interest in any vote related to her political future. The benefits to remaining a senator are considerable. Senator Mitchell is an employee of the state with a salary, health insurance, and assigned staff to help her with her work. And even more so, her Senate position has given her the special privilege to delay her trial for months. She had everything to gain from casting her decisive vote on January 27th and everything to lose. If she were expelled, she'd lose a job, health benefits, staff, and her trial would be able to proceed because she would lose the privileges in state statute exclusively granted to legislators. This complaint stands separate from her criminal case and independent of the other ethics complaint before us today. It doesn't need to wait for her criminal trial to conclude to be decided. The Subcommittee on Ethical Conduct should immediately act to prevent Senator Mitchell from participating in any vote associated with her political future and should take any and all disciplinary action warranted by this clear violation of the public trust. Thank you, Mr. President, members.
Thank you so much, Senator Jaskowski. Any questions for Senator Jaskowski? Senator, seeing that no one is rushing to the mic, I have... Senator Mitchell, you can also come up because if you want to ask a question, you are entitled to do so. Senator, here is my question. As you outlined on the day when, as you said, Senator Rasmussen brought forth this motion, and eventually there was a ruling from the president about whether such a motion was possible in light of our rules, that that the Senate president, and it's weird to talk in the third person, but I will do that for the record, made a ruling that that motion was inappropriate. Is that correct?
Mr. President, the president made a motion that it was out of order.
Absolutely.
And it was appealed. That's the motion, or the motion that was brought that is the subject of this complaint is the vote on the appeal, which would have dismissed the motion that Senator Rasmussen brought and dismissed the threat that was before Senator Mitchell that day.
So you would agree that it was Senator Friends who put forth the point of order. Is that correct?
That is my recollection too, Mr. Chair.
And it was ruled, and therefore that point of order was well taken. So the body was only speaking to whether that point of order was appropriate to be on the floor or not, and not the underlying issue as to whether Senator Mitchell was going to be expelled. Is that correct?
That is correct, Mr. Chair, and it dismissed the resolution proposal brought forward by Senator Rasmussen. So Senator Mitchell's vote, her no vote, or actually her yes vote supporting the president's appeal decision, her vote dismissed Senator Rasmussen's motion that he brought before the body. That's the effect, that is the direct and complete effect that that vote had.
Now, Senator Jaskowski, let's play this out. Let's say that the president had ruled that the point of order was not well taken. That could have happened, is that correct?
That could happen, Mr. Chair, and the body could have also voted that it was not well taken. And had Senator Mitchell followed Senate rules and not voted and abstained from voting as the Senate rules and state statutes say she should have, we would have had the same outcome, and that would have been, the Senate would have then entertained the motion to expel Senator Mitchell.
So Senator Drazkowski, you are one who is pretty well learned when it comes to parliamentary procedure, but you also understand that that there's a specific question that I think that you're avoiding to answer. The question is, if I would have said that that the Friends order was not well taken, that means then Senator Rasmussen, or at least the resolution that was before the body, would be before the body. Is that right?
That is
yes
correct.
Or no? Is that
right?
That
is correct, yes.
Okay. Senator Drazkowski, isn't it true that even if we got to that point where if it was not well taken, that another member could have stood up and asked for the body to be adjourned? Is that correct?
Any motion would be in order at that point. Any subsidiary, incidental, or other related motion that is in order would have been in order at that point, Mr.
So you would agree that it could have been adjourned, to recess, to lay the resolution on the table, any of those motions, and those are motions that has precedent according to Rule 28. Is that correct?
Any of those motions could have been brought forward, Mr. Chair, but the reality is they weren't. And they weren't because Senator Mitchell voted to support the president to protect herself from the threat of Senator Rasmussen's motion. So we never found out, Mr. Chair, because Senator Mitchell violated the rules of the Senate.
And so you would agree that if those other motions could have been brought, it's possible if there was a motion to adjourn that we still would have never gotten to the underlying motion of whether Senator Mitchell could or should be expelled. Is that correct?
Well, Mr. Chair, Senator Mitchell could have voted to adjourn before we took the vote on the appeal for the decision, but she didn't. And I could have moved a motion to adjourn as soon as the session was called to order, but I didn't.
And so,
and any of those theoretical things could happen, Mr. Chair. But I'm in this complaint, and the members that filed the complaint with me are only outlining the facts of what happened, and it's those facts and Senator Mitchell's conduct, the acts she took after making her decision to take those acts, which are before us today, and they are in violation of Senate rules, the state constitution, and administrative policy of the state Senate.
So, Senator Drazkowski, the reason why I asked you those questions, and I know that you want to stay on message, I really do understand that, but because we're talking about specific actions and whether someone concludes that the body would have gotten to the motion that was before it if Senator Friends' point of order was not well taken, that is speculation at this point as to what would or could not have happened because the president's point of order was well taken. That's my only point.
Well, Mr. Chair, if I could,
yes.
Mr. Chair, any of the things that you brought up are speculation.
That's correct.
First and foremost, because you introduced the speculation. But the custom and usage of the body, if you will, has suggested that if a point of order fails, that we usually don't see additional points of order. And I don't see in our history any times that I remember that the Senate adjourned in the middle of the proceedings. So those are all far-fetched pieces of speculation that you're bringing forward.
But it's a part of possibility. That's all I'm saying, that theoretically many different things could have happened. Senator Miller.
Thank you, Mr. Chairman. You brought up a lot of hypothetical situations there that I don't know the answer to, but what I was going to say is exactly what Senator Drazkowski just said. I've been in the Senate for 15 years, and I do not remember one situation where there was a motion before the body, and the body voted to adjourn for the day. So if we're looking at the custom and usage of the Senate, I don't believe that, at least I don't remember a situation where there's been a motion in front of the body and then the body is abruptly adjourned for the day. And furthermore, we can go down the path of hypothetical situations all day long. The reality is Senator Drazkowski's complaint is not a hypothetical situation, but an actual situation that is before the ethics subcommittee today.
And the only reason why I'm raising it is because I'm reading the rules. And under the rules, even if you, Senator Miller, are talking about adjourn in the middle, we have taken recesses right when there's been a bill up and that there's been a requirement. And if you look at Rule 28, that's number 2. It's a precedent. I'm just suggesting that there's a number of different things that could have happened, and the conclusion that means that would have been before us is not there. Senator Miller.
Yeah, thank you, Mr. Chairman. And I would just like the record to reflect that a recess is significantly different than being adjourned for the day. And I have been in a situation where the body has recessed when there's a motion in front of the body, but I don't recall a situation where we have adjourned while there's a motion in front of the body.
And Senator Miller, just so that we're clear, when I was reading from Rule 28, it's a number of motions. That's it. It's not just adjournment. And I'm looking at Rule 28. So it's not just adjournment. I use that as an example along with the other motions that are outlined in Rule 28. Senator Matthews.
Thank you, Mr. Chair. My question for Senator Drazkowski is towards the nature of your complaint with the decision made with the vote. And I want to ask you how it compares to other venues in the real world, potentially an employee facing disciplinary action with his employer at his place of business, maybe a corporate boardroom, maybe university personnel or other government officials. I tried to look through and research if there's ever a situation where a person potentially facing disciplinary action has a vote or a say in what the final result of that would be. I'm wondering if you could weigh in on that question, if there's any comparable to an average person in the state of Minnesota that could enjoy such a privilege.
Senator Matthews, I'm not going to recognize him for that question because that seems to be outside of the bounds of what we're here to talk about and to do, right? Because we're talking about what happened here, and for us to talk about other boardrooms and other things like that, I think that's a little outside of our bounds. If you have another question that would get to whether he knows of something here, what it would feel like, or any legislative body, you can certainly speak to that.
Mr. Chair, strongly disagree with you. Okay. That is absolutely within the bounds of weighing this decision with deciding how this decision lines up. I did research. I can't find anywhere else where someone's given the privilege afforded to them that they get a say in what their final disciplinary step would be. And so why would an elected member of this body be able to take such a privilege for themselves that is arguably not even in the rules, arguably is in violation of rules that are against personal interests, and a ruling that clearly is not afforded to anyone else in the state of Minnesota? That is my clear question for Senator Drazkowski.
And Senator Matthews, Senator Drazkowski clearly said that she was not voting on the ultimate question, but her vote did not allow the question to be put on the table, so to even be brought before the body. That's what the testifier indicated. So that's clearly different, and I'm okay if you have something else, but to go outside and start speculating as to what other people did or do in boardrooms, I just think that's a little outside the bounds.
Mr. Chair.
Senator Matthews.
Thank you, Mr. Chair. No, we're actually splitting hairs at that point because the parliamentary motion ahead is directly related to the question of disciplinary actions on the floor, potential expulsion votes that she prohibited from coming to the floor. So, Mr. President, I will put it this way. I did research to see if I could find any other avenue in our world today, in our culture, any other business, any other comparison where someone gets a say in a disciplinary move that they are facing with their employer, with whether a corporate, university, governmental setting. And it is not a custom and privilege of anyone that I can find that allows the member under consideration for disciplinary action to have a vote and a say in what the outcome that would be. And I'm very disappointed that you're not even allowing the discussion to the author of the complaint on this part, because that very well was a thought process potentially in his mind and the minds of the signees as to why they were bringing this complaint here today. And it appears that it is a clear violation from the rules, and that's part of the argument we're trying to get to at this complaint.
And Senator Matthew, just to be clear, at the very top of this, before I go to Senator Miller, Senator Drazkowski was clear and he was correct when he said this is not about anything else. This is about what happened on that particular day. No, but then when you want to expand it to have him talk about—
Mr. Chair?
Hold on. To talk about other things that falls outside of those bounds, that is all I'm speaking to. Senator Miller.
Mr. Chair, I'd like to respond to something you said. Can I do that?
No, I'm going to go to Senator Miller. And then we'll get back to you because you'll have an opportunity to speak.
But Mr. Chair, the only comment I was going to make is it appears that we tried to go down hypothetical road, and I just want to make sure we're not taking that path. We're not turning down that road. I think Senator Drazkowski has been incredibly clear on what his complaint is, and I'm just going to read it right from the complaint. Senator Nicole Mitchell violated Senate Rules 56.1, 56.3, and 56.4 by casting a vote upholding the ruling of the president that had the effect of preventing the body from considering her own expulsion. Her vote was the deciding vote on whether the Senate would consider her status as a member of the body. Mr. Chairman, I think Senator Drazkowski has been incredibly clear on what his complaint is.
Senator Miller, I agree that he's been very clear as to what his complaint is. What I simply asked about whether on that day that there are other intervening motions that could have been brought forward before you got to the ultimate question that was put forward by Senate Resolution Number 1, right? But with that being stated, I want to see if the committee would be available 15 minutes after session as opposed to at 5 p.m. so that we can, get in and still take the time while everything is fresh in everyone's mind.
Mr. Chair, could I address something you said?
You will have an opportunity to do that. I just want to make sure that we have a time, okay? Are you all, would you be available 15 minutes after session? Is my understanding session shouldn't take too long today. Okay. The only thing we have to do is check the room because there's another committee that potentially is meeting, but I'm not certain of that. But I don't think that they would be meeting until like 12:30. That's what usually happens. But would you be available, Senator Miller? How about you, Senator Matthews?
Mr. Chair, I can probably make that work, yes.
Thank you. Senator Kunish? Yes. Okay. Now, Senator Drazkowski, you want to react to something that I said before we get ready to go because we have to go to the floor. Senator Drazkowski.
Thank you, Mr. Chair. I'm trying to remember exactly how you said it, but you said that you used my words or said them incorrectly. You said that this complaint didn't relate to anything else. That's not what I said. What I said is it doesn't relate to the criminal complaint that is being entered or it is before Senator Mitchell. And to Senator Matthews' point earlier, Mr. Chair, if Senator Mitchell had followed the rules of the Senate, the laws of the state of Minnesota, and the administrative policy, 3 rules of the Senate, 5 points in Minnesota statute, section 10A.07, and the conflict of interest 1.35 in the administrative policy of the state Senate. Had she done that, the Senate would have conformed with the rest of the world. Back to Senator Matthews' question, the Senate would not have had Senator Mitchell involved in that discussion. She would not have had input into whether or not she was going to lose her job. But she didn't follow the rules, and she did that in order to avoid the threat that was before. And Mr. Chair, Mr. Chair, I'm almost done.
I gave you a minute. Listen, I gave you a minute to address what I said. You can still finish your your statement after we come back because you are back in the chair. Okay.
Thank you, Mr. Chair.
All right, members. What we're going to do is we're going to go to session. 15 minutes after session, then we're going to report back here, and if you could be on time, because we want to try to get through this as much as possible, okay? And Senator Drazkowski, you'll still remain under oath, but you'll be in the seat, okay? So I don't want you to think that you don't have an opportunity to speak to your issue, and Senator Mitchell, you'll have an opportunity to sit there and ask questions as well, okay? With that being said, we are in recess.